The pro-life community is no doubt excited that on Monday the United States Supreme Court decided to hear an appeal from the state of Mississippi of a decision by the Fifth Circuit Court of Appeals that struck down as unconstitutional its ban on abortions at 15 weeks. But we need to appreciate what is actually in front of the court that we might understand what we could expect from the court. And that's what I want to try to explain in just the next few minutes. The state of Mississippi asked several questions to the Supreme Court, three in fact, but the United States Supreme Court said we're only interested in hearing one question. And here's the question the court asked the parties to address. So when they actually file their briefs and argue it, here's the question they're supposed to answer. Whether all pre-viability prohibitions on elective abortions are unconstitutional. Now, what's at the heart of that question? From Roe through Casey versus Planned Parenthood, the Supreme Court has indicated that the state's interest in banning abortions and protecting the life of the unborn is not sufficient until fetal viability attaches. Now, what that means is not the viability of the pregnancy, but the viability of the fetus, the unborn child. Could the unborn child survive outside the womb with medical assistance? That's generally around 21, 22, 23 weeks. But the state of Mississippi notes that there are other cases where the court's interest has said that the state's interest is actually in the unborn life from the beginning of conception. Like, seems a little arbitrary, right? The state only has an interest at a certain point when we know when conception creates the life. And they particularly point to a case called Gonzalez versus Carhart, in which Congress passed a law banning partial birth abortion, and the Supreme Court upheld the procedure without really addressing the viability issue, because what they said was that essentially the procedure is so heinous, viability is not really the question. Of course, the procedure itself is normally only applied in late-term abortions anyway, so in some ways the viability issue wasn't really an issue in Carhart. So what Mississippi is saying is the federal courts think that viability is a bright line standard, that you just can't have a law that bans abortion prior to that. And is that or is that not the rule? And then the second question they really kind of ask, subsumed in that, is that standard really workable in light of things we now know? But let me quote for you from the petition that was filed with the Supreme Court what the state of Mississippi actually said. They said, to be clear, the questions presented in this petition do not require the court to overturn Roe or Casey. They merely ask the court to reconcile a conflict in its own precedents. Is viability the bright line rule or not the bright line rule? Are there other considerations that federal courts should consider that might militate against a bright line rule of fetal viability, the viability of the unborn child? Now, they did make this great statement in a footnote to that sentence. They said, if the court determines that it cannot reconcile Roe and Casey with other precedents or scientific advancements showing a compelling state interest in fetal life earlier in the pregnancy than those cases contemplate. Now, specifically, what they're talking about here is scientific evidence about fetal pain in the interest of the state in not allowing fetal pain in an abortion. So if they're saying, in other words, if your cases don't recognize that medical science might now show that the unborn experience fetal pain, well, they say then, in that case, quote, the court should not retain erroneous precedent. Get rid of it. Now, why is that important, and what are they getting at? And to understand this, go back to Casey versus Planned Parenthood in 1992 that refused to reverse Roe and upheld its central premise that a woman had a liberty interest in her body and continuing to have a baby. And so they said the state's interest really hinges on the viability of the unborn child. One brilliant thing about the brief of Mississippi is it points out with the creation of artificial wombs, this standard of fetal viability may begin at conception. You can simply have artificial wombs that ensure that if left alone, we're going to have a viable unborn child and a child at some point. So what they're really pointing at is in Casey, the court said, we're not going to reverse longstanding precedent unless we find that Roe's central rule has been found unworkable. So in other words, they're saying, is this standard of viability unworkable? And Mississippi is pointing out, yes, we think it is unworkable. Now, there's a second point that Casey raises that I'm going to talk about in a moment, but let me dwell on this and make sure you understand it. The idea that the standard of viability is not workable. There was an article in First Things, April 27th, by a friend of mine, Dr. Jerry Bradley, who teaches constitutional law at Notre Dame, and here's what he said. The vast bulk of the legal effort so far has been indirect, he says, focused on issues such as informed consent, clinic regulations, blah, 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 blah. But these efforts, he says, have about run their course. There are few additional babies to be saved by laws that do not simply prohibit some abortions. In other words, there's just only so much you can do when you're worried about clinic regulations and informed consent laws and those kinds of things. And he notes that he says, the pro-life movement secured laws in several states that prohibit abortions when they're sought for particular reasons, say due to prenatal diagnosis of Down syndrome, because of the unborn child's sex or race, eugenic abortions. Now, for reasons I've explained in a previous video, those kinds of laws are ineffectual to really prevent any additional abortions, but I'm not going to get into that. Watch that video. Bradley then continues, more often, states have passed abortion bans on gestational age. That's what Mississippi did. He says, after 6 weeks, for example, due to onset of fetal heartbeat. That's the Ohio and some of the heartbeat laws that we've seen. Or, as Bradley continues, after 15 weeks or so, because from that point on, the unborn baby feels pain. Now let's go back to Bradley's statement that these indirect efforts have about run their course. There are fewer and fewer babies that will actually be saved by them. The state of Tennessee, in April, just argued in front of the U.S. Sixth Circuit Court of Appeals with respect to its 15-week ban that actually 90% of the abortions were already performed before that 15 weeks. So that's what Bradley's saying. We're getting to the point where the return on the legislative investment in litigation is getting smaller and smaller unless we just outright ban some abortions somewhere prior to this viability standard, and even I would say 15 weeks. Of course, a heartbeat bill would do that. So, but he goes on and says this, the removal of the judicially created barrier of viability could let loose a cascade of pre-viability prohibitions. So in other words, he's saying the court has this viability standard, and Mississippi's in essence saying, well, that standard doesn't seem to work very well, and it doesn't take into considerations all the considerations that ought to be taken into consideration. So is there now another standard that's out there? Mississippi, White's little footnote, is saying, I don't know if you can come up with one. And if you can't, you just need to reverse this monstrosity called Roe versus Wade. But what Bradley's saying is, if they can come up with some standard that's perhaps between viability and being able to ban, something that splits the baby, so to speak, then states will start litigating and passing laws in those areas. And then he says this, and in due course, they will test the hypothesis that there is no principled coherent stopping point between removal of the viability standard and a flat-out reversal of Roe. So if you create something in the middle, states are going to test that one, and eventually you're going to test the hypothesis that there's just not a workable standard. Now, the second thing, and this is what I think is very, very important. You know the old expression, you put the last nail in the coffin. The unworkability of the viability standard would be the first nail in the coffin. But in the Casey court, the court said something else. They said that when we make a decision to settle a national controversy, we try to root it in something in the Constitution that both sides have to accept. And they said, so we're not going to reverse and upset this attempt at resolving a national controversy unless, he said, there's an equally rare precedential force to counter the inevitable efforts to overturn it. So in other words, we're going to find something in the Constitution that we think resolves this national controversy about abortion, liberty in the woman, and the viability standard. And we're not going to reverse it unless that standard proves unworkable, or in this second prong, you can come up with some equally rare precedent than the ones we relied on to resolve this case to counter it. Because we know everybody's going to complain. One side of the national debate is not going to like it. So the question would be, could states come up with an equally rare precedent to provide that second nail in the coffin on this unworkable standard of viability? And the answer is yes. What we need are hundreds, if not well over 1,000, pro-life legislators from all around the country filing an amicus brief, which I'm willing to help get prepared, to say to the Supreme Court, not only are pre-viability abortion bans constitutional, but we have an obligation to pass them according to the Ninth Amendment. See, here's the important part. The Ninth Amendment, adopted in 1791, has never been considered by the Supreme Court with respect to the effect the 14th Amendment had on the Ninth Amendment. They never looked at it. Why is the Ninth Amendment important? Because it says that the enumeration of rights in the Constitution, so that would be, for instance, the First Amendment, the Second Amendment, up through the Eighth Amendment, all of those rights, it said, shall not be construed to deny or disparage others retained by the people. Well, that necessarily means that we have other rights than those that are in the Constitution. And the ones that you've enumerated shouldn't be interpreted to deny or disparage the other ones that we've retained for ourselves. Well, what are the ones we retained for ourselves? Well, they're all the rights that we had at common law. Now, the question is then this. Well, the 14th Amendment was passed after the Ninth Amendment, David. And I would say, yes, that's correct. But is there anything in the 14th Amendment to indicate that it repealed or abrogated or nullified the Ninth Amendment? Well, no, there's no language in there like that. In fact, the 14th Amendment carries forward the language of the Fifth Amendment's Due Process Clause. Now, why is that important? Because in 1884, the United States Supreme Court was asked to address a question about the 14th Amendment and what the Due Process Clause of the 14th Amendment meant. And they compared that clause to the Fifth Amendment. And they said something very interesting. And this was not considered in Casey. It's never been argued to the Supreme Court. The Supreme Court said that the Fifth Amendment sets forth the law of the land as expounded by Congress. That's interesting. Not by the Supreme Court. And is to be interpreted according to common law principles. Oh, that's interesting. Having said that about the Fifth Amendment, they then said about the 14th Amendment that it's irresistible. The conclusion is irresistible. That the Fifth Amendment and the 14th Amendment are the same and to the same extent. In other words, the 14th Amendment didn't do anything beyond what the Fifth Amendment Due Process Clause did. And it should, presumably, be interpreted the same way the Fifth Amendment's Due Process Clause is interpreted. Well, that's great news, because the Supreme Court in Roe v. Wade and in Casey did not interpret the 14th Amendment according to the common law. How do we know that? Because at the common law, persons were all those whose life came from God. They were not considered artificial persons created by some law like bodies politics or corporations. So they were human beings in essence. And the common law said that this right extends to the child in the mother's womb. In fact, they have a right to property even. Now think about that. The 14th Amendment says no state shall deprive a person of life, liberty, or property. Okay, so the common law said persons were all human beings. And all human beings had a right to life because it didn't derive from the state. And they have a right to property. What's really curious here is Roe versus Wade acknowledged that the unborn can have a right to property. Now think about it. Those of you who are composition majors or love grammar, you got a subject, person, life, liberty, and property. How can the subject of a sentence be an unborn with respect to the word property and not be a person with respect to life, given that those words all refer to the same person? That's an incoherent grammatical construction of a sentence. So what these legislators need to do is file an amicus brief and say, you have forgotten about the Ninth Amendment, and you have forgotten about Hurtado in 1884 that says the due process clause of the Fifth and the 14th Amendment are to accomplish the same purposes and to be interpreted according to the common law. And according to the common law, the person includes the unborn, and they have the right to life. And so we as state legislators have an obligation and a duty to protect the unborn from having their lives taken by a third person doctor, the same as we would have the duty to protect you from your neighbor coming over and killing you. That's the final nail in the coffin. Let's make sure it gets nailed in.